if I release you, will you appear in court?
It's a possibility I will not.
Why?
All right, we're back now, and this is cause number CR 21-28106. And Miss McDonald, have you had the time you needed to conference with your client?
I have, Your Honor. And if I could put just a few things on the record.
You may.
Mr. Catton, I just want to go over a couple of things to see if you and I are on the same page. Do you recall me coming out to the jail on Saturday, May the 18th? It was in the evening after 7 o'clock.
Yes.
And that was the first time you and I had met face to face. Is that right?
Yes.
Do you recall that I talked with you about your case and that I had the discovery with you or with me about the case, and you had the opportunity to look at it if you wanted to?
I mean, I guess.
Do you recall telling me that you really didn't need to see that? You just wanted me to try to get you a time served offer?
Yeah, I mean, obviously, because I've been in jail for 3 years.
Okay.
Not prison, not penitentiary, jail.
Yes,
in psych ward for 3 years. I don't care. I want to get out of here. I'm ready to get out of here. Over 3 years. Let me the fuck out of here.
Sir. Your Honor, at this point, I have, even in breakout,
A PVC saw?
Okay,
Really?
Mr. Caton. Okay, Mr. Caton, I'm just going to go ahead and mute you. I can't hear two people at the same time, and we're trying to work through your hearing. Please.
Your Honor, even in the breakout session, I asked Mr. Catton a series of questions that similar to what will be asked in a competency hearing. He is able to understand that. He's able to talk to me. Although Mr. Catton, he's upset, clearly. I still don't have any concerns about competency based on his response to my questions that I've asked him. However, at this point, the only thing I know to do with what he wanted me to ask if the court accepted no contest pleas, and I've been informed that you do not. Under that circumstances, I'm going to ask for a trial setting, and I will file a motion for speedy trial. I would ask that since he has been in so long that I can be ready as soon as the court. I'm in trial next week, but as soon as the court and state could be ready, I would ask for the quickest trial date available, given the term that he has been waiting.
All right.
Oh, don't worry. It gets worse.
We'll ask the jail to unmute Mr. Caton. And sir, is it Caton or Catton? 1 second. They're going to unmute. Which one is it?
It's Catton.
Okay. I'm sorry.
Yeah,
I knew a judge. I knew a Judge Caton, and I assumed that it might have been the same.
Well, I hope we're not related.
Well, she's already deceased, sir. All right. All right. So it's my understanding then, Mr. Catton, that you're asking that the matter be set for trial. And at this point, it would be both cases would be set for trial. And we will get, is that correct? You want a jury to make the decision in your case? Because you're saying you didn't do it.
So the harassment of an officer that's being put back in there.
Absolutely. The state's only was going to dismiss it if you accepted the plea agreement, and that's okay.
Well,
I don't want to be in your business. I just need to know if you did it or not, and you're saying you didn't. So now I want to set it for trial, and I want to make sure you're picking what you want, and I think you want a jury. Is that right?
Whatever.
Well, it's your choice, sir. It's your case.
I'll admit to trying to steal a PVC saw.
Well, I don't need you to do anything for me. Let's go ahead and get it set for trial. You say you didn't do it. I want to know what you did to
I'm saying I was homeless and I was looking for a place to sleep. I wasn't there to steal anything. I was there because I'm homeless and I was trying to find a new place to sleep.
Okay.
I wasn't trying to steal a PVC saw, but
Okay, I don't see, right? He just admitted the whole thing. Okay. So you admitted it. How about we just How about we just find him guilty and call it a day? Time served, 3 years in jail.
If they think I was trying to steal a PVC saw, then I'll admit to trying to steal a PVC saw.
So we have an opening for trial setting.
Have I already been in jail long enough for what they want for spitting on that cop?
Sir, I'm not in the middle of plea negotiations. That's for y'all to handle. So let's look at, is August 12th a time frame the parties can be ready?
Huh. Oh, God.
Works for the state judge. I know we have a visiting judge on one case that week, but the state can be ready.
The problem is he admits to it, but then he won't plead to it. And that's what's keeping him there. It's frustrating. Like, he has a good point. He's been in jail too long for what he did already. I agree, but there's nothing the judge can do. She can't take a plea when you're not admitting to it. He admits to it and then sort of retracts it.
I'm available that week, Your Honor.
All right, let's go for August 12th. Now let's also set our pretrial. That'll be another time.
That is enough.
Your Honor, I may need to file another motion. I would ask that we keep that court date, but I may ask that he be seen by a doctor before then, out of an abundance of caution, based on what I just saw as well on the call.
I think you're going to have more information. The guy is obviously understands what's going on. This is not an incompetent person. This is somebody upset. He's been there a long time. I get it. I can't, though, take a plea of somebody who says they didn't do it. Yes, legally, and it's allowed. I haven't done it in 20 years while on the bench. And I'm not going to start now with Mr. Catton. So we need to go ahead and get him set for trial. I understand the frustration, but I'm not inclined, based on what I see, to appoint a psychologist to say the guy's competent. He appears competent. He appears very.
Oh, all attorneys prefer Zoom. It's way better than having to put pants on and, cram into an elevator in the Daily Center. It's way better.
Upset. Now, I would encourage you to assist in any advocacy he might need in the jail regarding proper medications, so that he has the medications he needs for any mental health issues he may have.
And I did, when I met with him on May 18th, he indicated to me he was getting his medications in the jail, but I will follow up to make sure that's still happening.
All right, and let's go ahead then and select our pretrial. If our trial date is August 12th, we want something about a month before that.
Does July 24th work for the court?
Well, that's a Wednesday of a criminal trial week. That's not a good time for the court. If the state would look at maybe a Thursday morning or Friday afternoon, that is a little bit more reasonable, because I would like to give you guys the time you need, and it starts chafing us in our jury trials.
I understand, Judge. The 25th, maybe, or 26th.
We could even do July 12th if that works for the defense.
I'm available on the 25th or the 26th.
I miss them too, Andrew. I really do.
I do have, I already have depositions scheduled all day on the 12th, Your Honor.
All right, we'll do July 26, 2024 at 1:30 p.m. That'll give us the time we need.
All right, so you're good, Ms. Williams, so we can hear you.
Okay, thank you.
Okay, victim panel.
Your Honor, she turned one in that was online. She didn't know who she spoke to, but someone told her that it may or may not be accepted and they would get back to her on that. I don't know if that was her attorney. I don't know if that was probation. But her conversation with me earlier today was the first that she was hearing that it was not accepted. I would note that probation did send an email to Ms. Lesh, letting her know that the Victims Impact Panel wasn't accepted. But at the end of the day, Ms. Lesh likely had withdrawn. We're not able to monitor every post-disposition matter. So it makes sense that Ms. Williams is only just finding out that the online Victims Impact Panel was not accepted. She says that she can have one to the court if the court's willing to give her a proof by date of 30 days.
All right. And
I can say in all honesty, I don't believe I've ever had one.
Online one was turned in back in February. Okay,
I'm sorry.
Yes,
what
sir.
day? Great.
February 15th.
She was in court that day and was given a new proof by Dave for the victim impact panel, so she was advised that it wasn't accepted that day.
Yeah, it
No,
was
sir.
due by- it was
I,
due by
I had
April.
a phone call. I had a phone call that said that they're debating on whether or not they're going to accept it. But I never received any other phone call outside of that. Like I said, I don't know who my probation officer is. I thought it was accepted because when I talked to the judge, he seemed to be okay with it. But apparently
No,
it
that-
was not.
Yeah, it wasn't. And Miss Williams, a lot of people kind of get into the situation that you did for various reasons. They don't understand the difference. I'm not going to get into why that is, but I think we've been fairly clear with people for some time now that victim impact panels online are not going to meet the requirements that we set out. Now, the judge you saw on February 15th should have said something to that effect to you, that you had to do a non-online panel and that it was due to the court by April 15th. So when April 15th rolled around and we didn't see it, that's why we sent you the summons for today.
Okay, I get that, but I was contacted by my parole officer, or actually she really never really identified herself. And I told her, it's like, well, the judge said it was okay. And she said, well, let me get back to you on that. And she never got back to me. Like I said, I don't even know who my parole officer is. So I'm kind of confused myself.
All right,
If that makes sense.
You don't have a parole officer. You don't have a probation officer assigned to you on this case. You're doing these things that the court ordered you to do.
Okay, I've already got a poll going, so I'm not going to do that. But I want to hear from the chat. Drunk or stupid?
Without having to report to a probation officer.
Right.
So
But what I understood is, like, I have somebody that I was supposed to check in with. From my understanding, I'm not talking about anything else. It's like my understanding that I had a parole officer and I did not know who that person was. So when I called to try to find out who my parole officer was, there was nothing that they told me. I'm like, wow, I would really like to send my paperwork into. So I honestly, I don't understand this system. A lawyer, because I didn't get any guidance in which to do. I understood that, hey, you have a parole officer. So when I called to find a parole officer in Thurston County, they're like, oh, no, it's different. It's different. But I didn't understand what was different. So I'm kind of left out in the dark, if that makes sense. And now you're telling me that I really don't have a parole officer. I'm like, who am I supposed to send my paperwork to?
you send it to the court.
But I sent all my paperwork to the court. I sent everything to the court. You're my third judge. So I sent everything in. I thought I can do it online. And you're telling me that I had one person that called me. She's like, okay.
Don't feel special, Judge. You're my third.
Let me get back to you.
Hey, Miss Williams, just let's kind of stop right here. It's not necessary that we go back over what happened before. Let's focus on what you need to do now. And it's really straightforward. You need to do a victim panel.
Okay.
Okay. And I think I'm telling you the same thing that Judge Pro Tem McDonald told you earlier that you need to do a victim panel and you have a deadline to get it turned in by. I don't know why you're confused, but it is very clear to
I'm
me that you
confused
are.
She doesn't qualify for the Mike Fixer program. I'll just leave it at that.
because when I put it in, the judge accepted it. That's why I'm confused. I will do another one. I mean, yes, I'm low income. I will do another one. I will do another one. I have no problem doing that. I
right,
just have
Ms.
to find out
Williams.
where it's at.
I think, Ms. Capone, I'm gonna assign your office to Ms. Williams's case because I think that if I don't, she's not gonna follow through.
Sure,
July
I'm gonna
31st
follow
to turn
through.
in.
If you look
July
at all my
31st
stuff,
to turn
I've
in.
always followed through. I'm gonna follow through.
Ms. Williams,
I will
Ms.
do it.
Williams, I
Yes.
need you to listen at this point, okay?
Okay.
July 31st to turn in a victim panel that is an in-person panel, no online panels. You've got to
Okay.
submit that to the court. That's it. There's nothing else
Okay.
to it, but I've assigned the public defender to you in case you get confused, you don't understand what you're supposed to do. They will tell you, they'll help you so that it happens.
Yes, I
Okay.
would very much like to be in contact. I
That's-
would.
That's all there is to it. Now, let's make sure that we have your contact number. So would you pull that up?
You have my phone number, you have my address. I will make sure to get it done. Like I said, the only thing I'm having right now is that I'm confined to my house because I have C. diff for the next 15 days. I will go in and I will do that.
Okay, and your
So
phone
what
number
I
ends
need
in,
is 30 days in which to do it.
yeah, your phone number ends in 5795, right?
Yes.
Okay,
And Your Honor, if I could address her briefly.
all right, and Ms. Capone has something to say to you. She's your attorney.
Ms.
Okay,
Williams,
Mr.
I'm the
Stone.
one who called you earlier.
Yes.
That phone number that I called you from, it's best to text me at if you have any questions.
Okay. So once so I just want to make sure, once I go in and I do my in-person victim income, can I text it to you or do I need to text it to somebody else?
You
'Cause like I
need to
said-
send it, Ms. Williams, you need to send it to the court.
But I don't have the court's information, is what I'm trying to say to you. Can somebody help me with that?
Ms. Williams, technically, and ultimately, it needs to get to the court. But if you text it to me or email me a picture of it, I will make sure it gets to the court. Just make sure you confirm with me that I got it and that I turned it in for you. So it doesn't
Okay.
get lost in the shuffle.
Okay, I appreciate this. Because I thought I was done. Apparently I was not. And I would like to be done with this.
All right,
Really?
Ms. Williams, I think
And-
you've got your instructions and you're good to go.
Yes. Thank you, Your Honor. I appreciate that.
All right, and Mr.
I can defer to other counsel. Thank you for.
Huxford, you want to
Patience.
jump in?
Just remand.
Am
her.
I
Would you like-
released right now?
Yeah, you're good to go, Ms. Williams.
Okay, thank you so much. I appreciate that.
Thank you. It's very generous. Oh yeah, the defendants are vibes
Counsel
here.
Reagan?
Yes, Your Honor.
Okay. My understanding, are you ready for Lincoln Park?
Yes, Your Honor.
Detective Stafford? Lincoln Park, can you hear me?
Yes, ma'am.
Okay, Detective, can you have Ms. Morales and Ms. Hoff both in the room? Is that possible?
Can you grab the other one? Yeah, set it down, please. Do not talk to her when she comes in here.
She wore her best AC/DC shirt. I'm so demented, it made me think of Fulton County.
You guys get there, just speak to. Stand right here. Your Honor, they're both here now.
Thank you, I appreciate it. The young lady with the white shirt, please say your full name.
Alonso Morales.
Thank you. And the young lady in the black shirt, please say your name.
Jessie Marie Corf.
Thank you. Ms. Morales, this is Magistrate Charfea. You're defendant 1 in this case. Ms. Corf, you are defendant 2 in this case. Case number is 8224711759-01 and -02. You both have an attorney. Go ahead, Counsel Reagan.
Reagan, on behalf of Ms. Morales and Ms. Corf, as to both ladies, waive before reading stand mute, been advised of the rights, Judge.
Thank you. I'm gonna enter a plea of not guilty. Ladies, you have the both same court dates, June 18, 2024, probable cause conference, followed by preliminary examination, June 25th, 2024. Both matters 9 o'clock at the Lincoln Park District Courthouse. Do you understand those dates, Ms. Morales?
Yes, ma'am.
Do you understand the dates, Ms. Corf?
Yes.
Okay. All right, ladies. So you understand you have some bond conditions. One is that you're not to have any contact with the complainant in this matter, Lori Mulligan. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Either of you are not to possess any firearms or any other dangerous weapons. Also, you're not to go to the Myers, that's on Dick's, as well as any other Myers stores while this case is pending. Do you understand that, Ms. Morales?
Yes, ma'am.
Do you understand that, Ms. Corf?
Yes, Your Honor.
Yeah, Detective, can you tell me in reference to Ms. Morales, what kind of pending matter she has? Any of assaultive?
Not that I'm aware of, ma'am. She does have a failure to appear for retail fraud out of the city of Southgate.
Okay, is it freezing there in the jail, or is this just defensive posture? These are the questions I have. This is why I need to run this past my chat.
Okay.
And Ms.
And
sorry.
go ahead.
Ms. Corf has 2 failure to appears out of Southgate for civil matters, and she also has a Lincoln Park warrant with us.
And what is the Lincoln Park case? Is that a misdemeanor or felony?
It was a misdemeanor.
And what kind of misdemeanor is this? A traffic?
Traffic, ma'am.
Thank you. Okay. Go ahead, Counsel Reagan.
Judge, I'm gonna be requesting personal bond for both young ladies. As the detectives already said, what the history is. Ms. Morales is in the process of filing for disability, Judge. She does have some health issues, does have an older child. Ms. Corf, I'm sorry, Judge is working at the Eagle downtown. No other history other than what the detective has stated. I'm asking for personal bond for both ladies. Obviously, no contact with the location or individuals. Obviously, they're charged separately with 2 separate situations. Ms. Corf charged with an accessory after the fact. Ms. Morales charged with the attempt larceny and the unarmed robbery. But I am asking for personal for both young ladies, Judge.
Thank you. Court has heard the representations of Counsel Reagan, has had an opportunity to read the allegations in the investigative report. We have both defendants. Okay. They are not in their 60s. The complainant is in her mid-60s. Okay. And while there's information or allegations in the investigator's report that Ms. Korf may or may not have known a little bit further information. Okay, the same thing with Ms. Morales, what Ms. Korf knew or did not know. Okay, these are the charges that we have. All right, so with Ms. Morales, okay, she's not going to get a personal bond using clear and convincing evidence standard. It's going to be a monetary bond. The court does believe that Ms. Morales, as well as Ms. Croft, both are a danger to the community in this particular matter. Ms. Morales, she's going to get a $50,000 cash, no surety, no 10%. Ms. Korf, on the other hand, is going to get a $50,000 10% bond. Okay, and both of them.
I don't know. For me, maybe you guys tell me, but for me, all this emotional nonsense just gives me a big fat eye roll. That's all.
Are going to be on a GPS. And do they both work? Counsel?
Judge, Ms. Morales is not working and Ms. Korf is working, but I'm sorry, Judge, I may have missed something. You said 50,000 cash and 50,000 10?
That
You
is
said
correct.
Is this based on you reading the investigator's report? I understand the flight risk aspect based on the warrants in the past, but you said they're a danger based on the allegations.
I do believe that they are a danger, okay, in this matter. It's questionable as to Ms. Croft, how much she knew, okay, and whether she was a direct participant or indirect participant. Okay, but I'm going with what I'm seeing here, okay? And is after the fact, Ms. Croft.
What, she didn't know? She accidentally participated in larceny at Meyer? I don't know.
Croft.
Possible, I suppose.
Kerf, I apologize. Thank you, Ms. Kerf. Korff. Okay. I do believe that both of them are a danger. They also have issues, but while I'm taking it into consideration, it's not as much for the flight risk, more of the danger. So for Ms. Morales, $50,000 cash, GPS tether home arrest. Ms. Kerf, okay, $50,000, 10%.
What does that mean, ma'am?
I'll tell you in a moment. 10%.
Two more that failed to qualify for the Mike Fixer program, which is probably best for them because the Mike Fixer program has a 100% failure rate.
And Counsel Reagan, you said that she works?
Yeah, she does work. She did work. I'm hoping she didn't lose her job now. She's been off work.
Yeah, I could have got out.
So she's working
right.
at the Eagle.
Okay, well, she's gonna get a GPS tether, work only. And so for both ladies, Ms. Morales, $50,000 cash. That means somebody has to post the equivalent of $50,000 cash for you to get out of jail. Okay, not only that, if somebody makes bond, you have to be placed on a GPS tether, which would be like an ankle bracelet, and you would be restricted to home confinement. Do you understand that, Ms. Morales?
Yes, ma'am.
Okay, Ms. Kerf, okay, your bond is $50,000, 10%. Your, if bond is made, which is $5,000, okay, you are also placed on a GPS tether. However, I would allow you to work only for that tether. Do you understand that, ma'am?
Yes, ma'am. I can't come up with that.
Okay, well, however, I'm gonna let you know both that whoever your attorney is, whether it's the same attorney or a different attorney, that attorney does have the opportunity to go to the judge in Lincoln Park District Court to petition a modification of your bond amount and bond conditions. Do you understand that, Ms. Morales?
Yeah, no.
Okay, do you understand that, Ms. Korf?
No.
Sorry, you said no, ma'am?
I don't know what that means, ma'am.
Okay, that's all right. Let me say this. Bond is $50,000, 10%. $5,000 has to be paid or some equivalent.
I have people trying to help me get the link, but I don't have it yet. I also have a court appearance, so Monday's busy. I will try to cover it if I can.
To $5,000, plus there's a GPS tether that would be placed. It's like an ankle bracelet, But however, instead of you being restricted at home, okay, you are allowed to go to work. And when I
Okay, but-
say those bonds, and this applies to you, Ms. Corf and Ms. Morales, is that whoever your attorney is does have the opportunity to go in front of the judge in Lincoln Park District Court and petition for a modification of your bond, change it to personal bond, reduce it to anything less than $50,000, 10%, to change the bond conditions, whether it's GPS tether or no GPS tether. So the judge in Lincoln Park District Court, whoever the judge is, okay, can have a hearing and can address the issue of bond amount and bond conditions. That would be up to your attorney. Do you understand that, Ms. Corf?
Yeah.
Okay. Do you understand that, Ms. Morales?
Yes, ma'am.
Okay, now I'm gonna let Counsel Reagan. Counsel, do you want to place anything else on the record?
Judge, I don't know. Maybe I'm missing it, Your Honor. I hear what the court is saying. You don't have much respect for this court. But I know this, we're not at the sentencing aspect. We're not at the guilt or innocence aspect. We're just simply at bond. Based on the fact Ms. Morales has no prior assaultive history. She's 50 years old, never been accused. She has a retail fraud warrant, but never been accused of any assaultive type history. And again, we're not trying to, bond is not a punishment thing, but, I guess I'm just a little confused. And I think, Judge, if it was a ongoing situation and maybe it's something I don't know, I don't have privy to, Your Honor, and I apologize, but I just think there's a less inclusive way to say for the tether, maybe house arrest, but a personal bond. I don't think cash bond that magnitude, I think, is excessive. That's all.
Thank you, Counsel.
Thank you,
Bond
Your
stay as it is. Okay. Thank you, Lincoln Park.
Thank you, Your Honor.
All right. All right, this is. All right, I'm gonna start doing some probable cause for Detroit, Counsel Reagan.
Okay. Cool.
Thank you.
All right, thank you.
Yes, sir.
The folks say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling.
Oops, there you have it. Now I need to check the poll, but I don't know how, because it doesn't show on the screen. Where's Yesenia? I need to teach Sonia how to fix these things for me.
Judge Simpson is never going soft. Webster is
I'm
always
looking.
showing heart. We are heading into that soft six summer. Did you miss the line? That's a bummer. The soft six never gets smarter than dumber. He's not the man, he doesn't need a number. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day I lost I would like.
Okay, it surprised me. Drunk, stupid woman is is dominating. She's absolutely dominating the poll. And that's saying something, because the other guy was banging his head on the table. And these knuckleheads whimpered through most of their hearing. But drunk and stupid takes the cake. There you have it. Thank you all for coming out. I appreciate it. I'll see you all soon.